Main Street, though, Washington. As you can tell, it's a sunny day on both sides of right on 1st Street Avenue, 101 East Main Street, though, Washington. As you can tell, it says 1st Street. Right on the 1st Street, 1st Street. And it's a clear day. We got review board at Mid-Columbia Library has a ABCs. Since they're prosecuted, Andy Miller's online, Andy at Miller, CO Benton, Washington, US. We got the ABC Corporation, Mid-Columbia Library, as by Don Clark. And then John Murr, Kate Combs at Lucy's. And then get Sasquatch, Kyle Sullivan by Dirk Sullivan here at Mid-Columbia Library. And then The Colors of Birds, early bird book. And this is the variety of a hummingbird. And the Pokemon Dinosaur A to Z. And everything's but nothing but the truth. You got the Lincoln Secret Weapon on DVD. America, the Muslim Worlds, without her, you'll be inspired by Rush Limbaugh. Well, maybe that one. And then the Civil War, and that's the untold rate compelling bonus. And this is the rare artificial 50 years anniversary of Siege Victory. 14 minutes, 12-page view guide. This is authorizing Henry Dent program in DVD. And then we got the Abraham and Mary Lincoln House divided. And this is the Fair Fight War, Blind with Weeping. And this one has the exotic composers of all the stuff on PBS. And then we got the War of 1812 Libraries. 1819 was 1812, and this is the Mid-Columbia Libraries, but this is the original the War of 1812. And then we got Al-Qaeda, Great Escape Military, a Media of Terror trial by Flip Smucker. You can't miss that one. And then we got the 1776, and that says Bin Laden, and we got the 1760 David Muggen. All of Truth. Very sorry to select. This is the new reading, the new research available in laptops. New laptops, as you can tell, it's online, faxed to Andy Miller, P.O. Benton, Washington, U.S. Kennewick, Wrestling Basketball.
But the fraud ruling doesn't justify complete relief, in fact, or the consequences of finding fraud, because that alone requires reversal. The district court granted the defendant complete summary judgment, but the fraud ruling doesn't justify complete relief. That's because fraud in the PTO is a narrow offense. The remedies are limited. If fraud is proven, there are two consequences. First, registrations are canceled. And second, any claims for infringement of a registered mark are defeated. But that's it. All other claims survive untouched.
What claim are we talking about here?
I'm sorry, Your Honor?
What claim are we talking about here that you think survives? Because if it's an argument that there should be an infringement claim based on an unregistered mark, I don't really see any argument that there's power in an unregistered mark. Nor do I see any basis for a claim. I mean, the alleged fraud is the misstatement that these trademarks were in use, notably the fake photographs. They weren't in
Let me start with the unfair competition claim.
So we're off of the unregistered claim. I mean, I just don't say anything to that. So if you think there's something to it, I need to hear it. Otherwise, it's argued, but it seems to be purely theoretical.
So, Your Honor, if you look at paragraph 6,
I don't ask whether you've pled it. Are there any facts to support it? If in fact this trademark was not in use, how do you have an unregistered claim?
So, Your Honor, there's a couple questions there. Let me try to take them in turn. First, we use the Life is Beautiful mark in connection with art shows, art installations, and art exhibitions.
None of the other products that are submitted in those fake photographs, I take it.
Yeah, Your Honor, they're not fake, but I'll come back.
Well, okay, they're real photographs of something that wasn't true, so you can call them what you want, but...
Your Honor, those art exhibitions and art installations were under the name of the title of the show was Life is Beautiful.
Which is about as generic a name as can be. I mean, when I think of Life is Beautiful, I think of the film from 20 years ago. I think of, indeed, when I thought about this the other day, you may not be old enough, but there was a hit of sorts in 1966 by an artist purporting to be Napoleon the 14th. They're coming to take me away, ha. And in there, that phrase, Life of Beautiful, reappears several times. So,
as Your Honor knows, context is king in looking at marks, and Life is Beautiful is neither generic nor descriptive of an art show. Might be descriptive of life, but it's not descriptive
So is the answer,
of art
is
show.
that the, forgive me for interrupting, but is that the answer to Judge Clifton's first question, which is what claim are we talking about? If you set aside, if we agree with you that maybe the ruling was too broad once there was a finding of fraud, what unregistered claim are you talking about?
So at the time that the complaint was brought, there was not a registration, but there was a common law mark.
But art shows or festivals?
Yes.
Okay, so why does that survive?
That survives because that claim is not based on a registered mark, as pleaded in the complaint. In addition, our unfair competition claims don't rest on the use of any mark, let alone a registered
But
mark.
here's the problem I have with any unregistered Lanham Act claim for Life is Beautiful. And I think the problem I have is that in the district court, it seemed to me that what your team argued, I think relied on exclusively, was the presumption that arose from the 2014 registered mark. Isn't that right?
Your Honor, we did brief that extensively, but the district court found, and there's evidence in the record, that we used Life is Beautiful as our mark in connection with art shows and art exhibitions.
So how does it, I think you relied on the 2014 mark.
Yes.
All right, so that's just a non sequitur as far as I can see. I need help with that because that mark, that registration, postdates the allegedly infringing conduct.
Yes, and even if Your Honor accepts that, there was still use of Life is Beautiful as a mark in connection with art shows and art installations.
Okay, then you get back, I think, to my other problem, which is that's not what you pled in the district court. You pled reliance. I think you relied on the 2014 mark, registered mark.
We did, Your Honor, but we also put on evidence that we used Life is Beautiful as the title of 7 art shows, and the district court credited that evidence in its order.
So your answer to my question is, and I'm not trying to give you a hard time, I'm trying to make sure I understand. Your answer to my question is that you did not exclusively rely on the 2014 registered mark.
That's right. Even if you disregard that mark as evidence of use, there was evidence of use as the district court credited on pages 12 to 13 and footnote 1 of the excerpts of record in its order. Now, to get back to the unfair competition claim, that claim survives.
Could I, before counsel, excuse me for interrupting, but I don't want to get off that mark. Didn't the 30B6 designee concede that the Life is Beautiful phrase was not used as a trademark?
No, Your Honor, that was only with respect to the pop art. As to the trademark, we used Life is Beautiful as the title of art shows. And there's authority that when you use a title repetitively in a series of works over time, that can acquire trademark protection. And that's exactly what we have here. But independent of trademark, we have an unfair competition theory that survives. The unfair competition theory is that the defendants' deceitful, underhanded tactics to build a festival on the backs of our hard work. They took our images and art off the internet, put it into pitch documents, they put on their social media accounts pictures of our art. That is an unfair or deceptive business practice. That survives irrespective of any trademark that might be claimed in this case. And as Professor McCarthy has explained, we do not lose our common law rights, we do not lose our state law rights, and we don't lose our Lanham Act rights, so long as they're not related to registered marks. All of those claims survive, and this court should reverse the summary judgment on that basis alone. Now, I'll come back to use just briefly because I want to make sure I answered all of Judge Clifton's questions. The district court made a determination, this is on pages 12 to 13 of the excerpts of record, in footnote 1, that we titled an art show in 2008, Life is Beautiful, and that thereafter there were 6 additional shows titled Life is Beautiful. Now, because those titles are eligible to acquire trademark protection, we pleaded an unregistered claim for infringement of that mark. That's our unregistered trademark claim that survives the district court's fraud ruling. In addition, we have the unfair competition claims. So all of those claims should be reversed, and we should be allowed to pursue those claims on remand in the district court. Now, the only other potential basis that they have articulated for affirmance of the fraud on the PTO ruling is that they were harmed. But they weren't harmed, and the public wasn't harmed, and there's no evidence of that. It's entirely speculative that there was any harm at all, because no competitor came forward with evidence. They didn't elicit any evidence that somebody was deterred from entering the market. We didn't go out and threaten people or act as a monopolist, as in the 1969 Northern District of Illinois case that they rely on. None of those facts are present here. And in terms of the harm to the defendants, they were going to be sued anyway on the unfair competition theory that I mentioned and on the unregistered trademark theories I mentioned. So there was no extra harm to them from being sued. Not to mention the fact that it would raise serious First Amendment and North Pennington problems if this court were to hold that merely claims. And this court held in the TrafficSchool.com case that, I'll read you one sentence if I may, using litigation to shut down a competitor who uses unfair trade practices is precisely what the Lanham Act seeks to encourage. So the idea that we could be responsible for filing and maintaining a lawsuit and causing harm is inconsistent with this court's precedents.
I have a couple questions about fees that I want to give you a chance to answer before you sit down. My first question is whether your complaint was ever amended to drop the claims, the Lanham Act claims rising from the 8 registered marks.
I don't believe so, Your Honor. Those were dealt with on summary judgment before there was a further amended complaint.
Okay, so my understanding is that there was discovery that was conducted. You received a letter letting you know that the summary judgment motion was coming. Your team responded by surrendering the 8 registered marks.
That's correct.
But the complaint was not amended.
That's correct, because they moved for summary judgment within a matter of weeks after that surrender or withdrawal. And at that point, the summary judgment briefing took over and the district court made its decision. There wasn't a need at that point to amend the complaint. And certainly we're not pursuing those claims. We've surrendered and withdrawn those 8 registrations.
All right, thank you.
I have a question, counsel. In the absence of the district court's order of cancellation of the trademarks, is there, in your opinion, any limitation on the amusement arts ability to re-register those same trademarks later?
So, Your Honor, the district judge's ruling cancels the 8 registrations, not the 9th, and there may be some confusion in the briefing on that, but the order doesn't touch the 9th. But the district court's order does cancel the 8 registrations. In our view, that's moot because we've surrendered and withdrawn those registrations. We don't intend to use them. It's sort of academic at this point. But as a matter of law, the court's ruling cancels those registrations.
Counsel, the question goes to capable of repetition, right? We know the
Exactly.
exclusiveness doctrine goes to capable of repetition. So what we need to know is, could you go back and re-register those marks?
We do not intend to re-register those marks, Your Honor.
Well, that's one way of answering it. And is there any dispute in this record that the products identified in the trademark registrations were never sold? Any dispute to that?
Your Honor, I would answer the question this way. It's not disputed that those registrations, the applications, were inaccurate. We acknowledge that. But those photos, for example, were real photos of real pieces of art. The mistake was in the failure to recognize on the part of my client's executives that they were supposed to put on, if they had any, evidence that they sold the products as opposed to objects of art. Take the spray can, for example. That spray can was a piece of art. Mr. Brainwash created it. It was for sale, like all of his artwork. But it wasn't for sale as spray can. Right? It wasn't going to be sold for anybody to go and put graffiti on the wall. It was an art object. So that's an example of how our evidence is consistent with the absence of a subjective intent to deceive. Unless there are further questions, I'll reserve the rest of the time. Thank you.
Good morning. May it please the court, Tamerlane Godley, Munger, Tolson, Olson, on behalf of Life is Beautiful LLC and Downtown Las Vegas Management LLC. I'll refer to both collectively as LIB, or Life is Beautiful. Music Art claims to have used the Life is Beautiful mark on over 250 goods, they claimed. To support its claim of use, they mocked up and submitted photographs to the PTO purporting to show use of the mark with the sale of goods. It is undisputed that those photos did not show sale. They had to make up tags and put them on pieces of merchandise that they never sold. Amusement Arts witnesses admitted during deposition that AA never sold these goods with the LIB mark. Amusement Arts fraud on the PTO was brazen and widespread. It improperly monopolized the phrase for 8 categories and 250 goods over a period of years. But Amusement Art did not stop there. It used those registrations as the first claim and the centerpiece of its suit against Life is Beautiful.
They surrendered the claims relating to the registered marks before you filed. So why weren't those claims removed?
So at that point, in terms of the cancellation, the law is clear on that, Your Honor, that unless you renew or reapply for those registrations, then the cancellation, the summary judgment on the cancellation motion was proper.
I don't think so, counsel. They would have to reapply. There's new applications and new, presumably, photographs and other, new supporting material.
Right, but then they could get them reissued to the date of their claimed use.
Those would be new applications. We're talking about the existing application.
Right, but it wouldn't change their rights.
It would change the ruling. It would change it wouldn't be res judicata. It would be a new application.
So they could, if they just voluntary surrender them, then they could go in there.
Please the court, Chris Cariello for appellant Craig Cast. I'd like to reserve 3 minutes of my time. I've been asked to address 2 points, and I'll give the answers in turn. First, on vicarious infringement, the rule that decides this case is that a direct infringer, here only websites avoidance of license fees, is insufficient standing alone to satisfy the direct financial benefit prong, where otherwise, That requirement would be satisfied in virtually every case, conflicting with over half a century of case law and the underlying logic of vicarious infringement. Second, the district court should have known instruction on willfulness, misstated the law on that, on what willfulness requires. Willfulness requires recklessness. It should have known instruction is a negligence instruction, which enabled the jury to hold Mr. Cass liable as a willful infringer for mere careless conduct. And as a result of these errors, Mr. Cass has been saddled with extraordinary liability for the actions of a bargain web developer on a website that no one ever saw. Turning first to the direct financial benefit requirement, I want to make a broad legal point, and then I'll turn back to the record. On the law, in every single case of vicarious infringement, it's going to be true that a direct infringer infringes and that a direct infringer does not pay a license fee in order to permit that conduct. That's going to be true whether or not the infringement is a draw for the alleged vicarious infringer. That's going to be true whether or not the alleged infringement somehow leads to profit, to an inflation of the bottom line for the alleged vicarious infringer. It's going to be true virtually no matter what. And that rule departs from the traditional rationale for vicarious infringement in that way. Vicarious infringement is infringement over and above direct infringement, and it's appropriate only, as Shapiro and Bernstein put it over 50 years ago, when there's an obvious and direct benefit. And the rationale there is, in that circumstance, it's fair to require a defendant to police the potentially illicit conduct of others. In that situation, it's fair for a defendant to have to compensate a plaintiff for the invasion of the plaintiff's legal rights that is occasioned by another. That rationale is not going to be triggered every single time a direct infringer doesn't pay license fees. That's all this court needs to hold to decide this case. That's what Erickson proceeded upon before the trial court, a theory that avoidance of license fees was enough. On appeal, Erickson has suggested some other theories, and so that brings me to my factual point. On this record, Mr. Cass got no benefit whatsoever. Mr. Cass saved not a dime on web development fees. Mr. Cass, there is no evidence that anyone ever visited this website. There is no evidence that this website ever led to customers. And there is certainly no evidence that these photographs, that this infringement by only websites led to anything that benefited Mr. Cass. In fact, Only Websites was acting averse to Mr. Cass' interests when it infringed here. Mr. Cass' contract with Only Websites required Only Websites to provide 2 photos per page. So Only Websites is breaching its contract here when it infringes Wells Fargo's, the photographs from Wells Fargo's webpage and provides them instead of the photographs that it was contractually obligated to provide. The only way Erickson can win on this issue, it says non-payment of license fees will always suffice, with a rule that says any infringement in any commercial context, on any commercial website, indeed within any business, qualifies per se because it's wrapped up somehow in a for-profit enterprise. That's not the law. That's never been the law. And there's really no reason in this case to expand it, given that there's nothing on this record that suggests any benefit. I'm going to turn to the willfulness point now and the should have known instruction.
Was this instruction, for lack of a better phrase, conjunctive? I mean, the instruction said, if he knew, point 1. Point 2, if he was willfully disregarding the holder's rights, or 3, should have done. How do we know the jury didn't make its willfulness finding on points 1 or 2?
So we don't know that for sure. What we do know is that the jury was permitted to find willfulness on the mere negligence instruction on the basis of should have known. It is phrased in the disjunctive. Each of them is an or. Ericsson's counsel told the jury, you don't even need to find recklessness in this case. Should have known is enough. And so we don't know exactly what the jury rested its decision on. That's
So
the problem.
the presence of the phrase should have known infects the whole instruction?
Yes, Your Honor, because it lowered the bar. It lowered the bar from culpable conduct, the sort of egregious, blameworthy conduct, down to careless conduct. Over and over again, I want to emphasize how similar this instruction is to instructions that have been rejected as negligence instructions in the past. The BMG case in the Fourth Circuit, where the defendant, quote, knew or should have known of such infringing activity. Comil, a case in the Federal Circuit, quote, knew or should have known that its actions would induce actual infringement. Brown, a Seventh Circuit age discrimination case, knew or reasonably should have known, and then the instruction here, should have known that only websites' acts infringe plaintiff's copyright. All of those instructions rejected because they're negligence instructions where recklessness is required. I see that I'm running up against the time that I've reserved. I do want to get to the record here too, because I think this is plainly prejudicial error on this record. 3 points I'd like to make. First of all, the contract with only websites, unambiguous. This court can decide that as a matter of law. Establishes that only websites was required to take care of the copyright permissions for photographs that it provided, for photographs that Mr. Cast sent. Mr. Cast was responsible for those copyright permissions, but these aren't photographs that Mr. Cast sent because the jury specifically found that Mr. Cast did not copy anything, and you need to copy to send. So these are not photographs that Mr. Cast sent. The Zillow case that this court decided last week, we put in a 28J letter, establishes the importance of a third-party contract, just like the one here. And of course, the Safeco case that the Supreme Court decided says, if a defendant reasonably determines its legal obligations, then it can't be held to be reckless or willful. 2 other quick points. Mr. Cast respect.
It's things related to Hindu values and the
26, when Mr. Cast understood he needed to secure a license, he secured a license, he paid for it, and then sent those photographs to only websites. And one final point, the same is true of Mr. Cast's conduct the moment he learned of only websites infringement by receiving a cease and desist letter from Ericsson. He took prompt and effective action in order to stop that infringement. Again, the Zillow case recognizes that that is a significant factor, and it absolutely forecloses a finding of willfulness. Thank you for the rest of my time.
Is it 101?